All right, now we heating up. So tell a friend to tell a friend about my YouTube channel because now we heating up. We talking about witness tampering, right? And I'm gonna let you know ahead of time. I did this particular document, which is number 226, first, because right after this we're gonna go into legal counsel intimidation, right? So, um, most of these guys, 9 out of 10 of these guys had felonies, and in my opinion, showed a pattern of criminal behavior, and not just a pattern of criminal behavior, very violent. If you take a listen to the transcripts that I'm about to read, I'm pretty sure you will draw your own conclusion to the same that matches mine. So, without further ado, let's get into this here case. As you guys see, you see the names involved. November 17th, 1992. You know the names. You understand? By now you should know what court district this includes. So, it says, Deary District Judge, the United States has moved for an anonymous jury at the trial of the above captioned case because of the extremely violent nature of the crimes charged, the past willingness of the certain defendants to subvert the judicial process, and the publicity this case is likely to attract. Defendants oppose the government's motion, arguing that anonymous jury is not justified and will interfere with the defendant's fundamental right to an unbiased jury. For the following reasons, the government's motion is granted. That is kind of crazy. That motion, in my opinion, says defendants oppose the government's motion, arguing that an anonymous jury is not justified. In my opinion, after reading this, an anonymous jury is most definitely justified. Because, in my opinion, these boys wasn't playing fair at all, right? So I'm gonna skip the discussion because it's just kind of citing cases on why, to give some type of reference on why they definitely should have an anonymous jury, and they're using other different cases from the past. So I'll skip all of that, and go right into this discussion here. Start here. In this case, the dangerousness of the defendants is amply demonstrated. 9 of the 10 defendants have prior felony convictions, and several defendants have been convicted of violent crimes. The defendants are charged in a multi-count RICO indictment with membership in a violent drug organization known as the Supreme Team. The indictment also charges the commission of 9 murders. The government's affidavit states that these charged murders include the beating and suffocation deaths of 6 Colombian drug suppliers and the shooting of 2 Supreme Team members who lost the organization's favor. According to the government, 2 additional murders are not charged but will be the subject of proof at trial. In addition, the government plans to present proof at trial that the Supreme Team routinely protected its drug business by reporting to violence, including beatings, torture, and rape. Let's do a sidebar right there. I think I already did the videos introducing Trent William Morris. And if not, we definitely about to get into some of this conversation here about those 2 additional murders. However, in my previous videos, I did ask about the rape allegations. I wanted to know pretty much just why anybody's name would be affiliated with that. Damage control was attempted, but it was really confusing to me. Like, yo, just answer the question, bro. Like, it's just easy. Because for me, I'm just like, yo, I ain't got nothing to do with this. You understand? That person is definitely lying, and I never did that. Now, what I heard was, yo, that person is a liar. Do not listen to anything that person says, because they are indeed an informant and a snitch. And my logic and reason told me, just because someone's an informant and a snitch doesn't mean they're lying. And in fact, if they are offered a 501k, chances are they might not be lying, because the criminal justice authorities just want to see if your testimony aligns with information that they already have, right? They don't always say what they got and what they know already, but a lot of times they already know what's the deal. So people, I showed you the date, all right, 1992. I don't know when these other people was offered to sit down, any type of proffer or 501k letters and all of that, right? That would be a whole different investigation for people to kind of look at. However, that word came up again as we're reading this, that R word. Now, let me just tell you something. I don't take kindly to none of that, man. Not for people who take up for people who do that. I don't want to hear, yo, you know how it was back in the day. What are you talking about, my man? What are you talking about? Shut up. Shut up. Fact is, you had some really grimy people on this earth that might have deserved the sentences they got. Now, I will, like I said, I don't know if I said it in this video, but I will take in consideration, this was 30 years ago. So people could have changed. These are younger versions of these guys that are either out today or fighting for their life to get out of incarceration, because you be sat down long enough, you realize, yo, I was wilding. Or some of these people could have came back out on the same timing, ready to get busy again. We will see. We will see. All I'm saying is, as you can see, I'm triggered by that, because when you don't need to do that and you just feel like that's part of the lifestyle of crime, wrong. Like, if no one steps in to say, yo, that's not correct, then it gets crazy. Let's continue on. Unsidebar. The government also alleges that that defendant Gerald Miller and his associates have interfered with the judicial process in the past. The government expects to present proof. Hold on, let me put back on the. There we go. To present proof at trial that 2 murders were facilitated by Gerald Miller's ability to obtain confidential law enforcement data through corrupt dealings with law enforcement officers. The indictment also charges defendant Miller with threatening a witness and his relatives with violence in order to discourage that witness from testifying at Miller's 1991 state trial. According to the government, Miller and his associates made repeated attempts to thwart the testimony of Trent Morris before, during, and after the trial. These attempts included the communication of explicit threats of violence to members of Morris' family and suggestions that Morris recant or invoke the Fifth Amendment, or that Morris' brother testify that Trent Morris' testimony resulted from police coercion. Can I do a sidebar right there? I don't want to make this video really longer than what it is. I'll stop doing sidebars, but you know, I don't know what made Trent get into this lifestyle. I'm just going to assume that it might have been money, right? But I don't think it was worth it at the end of the day if he decides, like, if you couldn't walk away, right? And what made you stay? I'm pretty sure you could walk away. I'm pretty sure if he would have walked away before he was ever nabbed by police, he would have just explained, yo, I'm out. I just, I'm not feeling it anymore, yo. I appreciate this. So whatever you need to say, yo, I don't really want to do this no more. I'm not comfortable. Most people be like, yo, you good, bro. You know what I'm saying? What you gonna do? I'm probably gonna go get a job and work. Yo, you crazy. We making wild money. What you want to do that for? Da 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 da. At the end of the day, you would have been let out. You understand? But you kept on going till you got nabbed by the police. It's something in your gut that had to tell Trent. Had to tell him. Yo, because that's the intuition we all usually get. Yo, something's gonna happen. Boom, you get nabbed by them D's, and now you don't want to do the time, knowing full well that, yo, if I get caught, I'm gonna have to do time. Now you don't want to do time. Now you want to tell on people. On sidebar, let's get back to it. According to the government, Miller and his associates made repeated attempts to I read that. On the night after Morris testified, two of his relatives, one of whom Miller had explicitly named in a threatening conversation, with Trent Morris' brother, were murdered. Although the investigation into these murders is not complete, the circumstances surrounding these vicious murders strongly suggest a connection to Morris' testimony at Miller's trial. The court must also consider whether the defendants possessed the means to endeavor to influence or interfere with the jury. The government's affidavit submits that members and associates of the Supreme Team are or will be at large by the time of the trial. The government identifies several individuals who have demonstrated continued participation and interest in the Supreme Team's affairs, and who would, the government suggests, be capable of approaching a juror at their own initiative or at the behest of someone else. For example, the government alleges, let's just stop right there. Let's just stop. I want to do a sidebar. I know I just said I'm not going to do too many sidebars, but give me a sidebar for a second. I think the government is playing games. They need criminals, right? I think if they really wanted these individuals or these type of individuals off the streets, they could immediately stop it. But what does that immediately stop? It also immediately stops the necessity for parole officers, for court officers, for the van driver, for the judge to have overtime, and for the clerks, for all this overtime that the police are awarded. So there's a matriculated balance of crime ratio versus, you understand, arrest. And yeah, I could be pissed off at my people, but I could also be pissed off at the government for playing and allowing such shenanigans, which are not really shenanigans. Shenanigans is a playful word. There's murder going down in these streets over money that is allowed to be made illegally just so that the cops have something to do, Jack. And murders are being facilitated. And other things. So, I just wanted to say I'm not stupid. Right? Anyway, let's get back to Assistant U.S. Attorney Caldwell's affidavit sets forth that Miller told Trent Morris' brother, William Morris, Gerald Miller, I'm just going to say GM, But what I'm saying is this. If a nigga thinks that he can get on the stand, testify against me, and then convict me, and then think that people out there, they ain't gonna be upset about it, then that's a different story. See what I'm saying? WM. Yeah. GM. So that's the only spot that he has put people in. If you notice, Robin's still staying in Baisley Projects. WM. Yeah. GM. They dropped charges and she didn't move. See what I'm saying? WM. Yeah. GM. Because if I really wanted to do anything to anybody, it'd be a snap of a finger. One individual, Troy Jones, aka Baby Wise, who is on parole, has already demonstrated a willingness to interfere with the judicial process by acting as a go-between in Miller's efforts to intimidate Trent Morris. Finally, with drugs and violence as its theme, the case will likely continue to attract considerable media attention, possibly thrusting the jurors into a fishbowl environment that could make it more difficult for them to function as fair and impartial jurors. Anonymity would, of course, offer responsible jurors an effective level of insulation against the resourceful New York City media. Can I just say right now, can I ask you to hit the like button? But can I also ask you to hit the hype button? There's a hype button. And you're like, I don't know where that's at. You see the comments? Try to push the comments to the left or something like that. And then there should be a hype button. Hit that joint. Hit that joint. You understand? For your boy. All right? Because I got a lot of different information from this. I'm not here to be judgmental. This is public information that I just so happen to be giving you. Because it's not like you was going to go get it on your own. But apparently you enjoying it because you're still watching it. So hit the like button for your boy. Now let's get back to this. After considering the above factors, the court concludes that strong reasons exist to believe that the jury needs protection in this case. Not only are the defendants alleged to be dangerous individuals charged with large-scale drug trafficking and numerous violent offenses, but the evidence also strongly suggests past attempts by Gerald Miller and his associates to interfere with the judicial process. Moreover, the defendants appear to be part of a group that possessed the means to harm jurors, and the trial is likely to attract publicity, which will enhance the likelihood that jurors' identities will be subject to public disclosure and inquiry. Although the evidence linking Gerald Miller to the murder of two of Trent Moore's relatives is somewhat circumstantial and speculative, the court finds that the circumstances of these murders contribute to an informed assessment of the risks to the judicial process, which cannot be addressed. The court emphasizes that the impaneling of an anonymous jury would not interfere with the defendant's fundamental right to an impartial jury. The court's voir dire will sufficiently uncover jury bias as to issue in the case and as to the defendant themselves. And then it's citing some cases there. In addition, as the circuit in that case recognized, we have found that the danger that the jury might interfere, that the need for additional security was attributable to the character of the defendant, was minimized where the court took care to give the jurors a plausible and non-judicial reason for not disclosing their identities or for taking their security measures. ID. I'm going to take a sidebar right there, and I'm going to say this. Like I said, in my next video, I will show that it appears that individuals were also might have been allegedly threatening their counsel in one form or fashion or other. We will go over those paperworks, right? So, in my opinion, reading this, these people were not good for society. I would have sat these individuals down for a 30 piece. And actually, some of them got sat down for longer. They just so happened to get out. But if the people are being real with themselves and they're reading this and they listening to this, then they have to know, yeah, I had to get sit down because I was wilding out. If they do not come to that same conclusion, then no, they are not rehabilitated and they are not worthy to be out on the streets. And I'm saying that. Now, anybody can massage anybody's ego if y'all want. Y'all do what y'all want. I do what I want. You want to massage your man's ego, boost him up and tell him, yeah, you was out here killing other people. Yo, you the man. You do that. You understand? But too many serious topics are being brought up for me to even consider that. I don't know. I understand why people did it. Like I said before, there's money involved. Let's get back to this. Rather than interfere with the jury's ability to act as an impartial trier of fact, the impaneling of an anonymous jury in this case will protect the impartiality of the jury by providing the juries with an added level of comfort that will enable them to properly exercise their vital role. The court realizes that resolution of this issue is by its very nature speculative. But although speculative, a common sense analysis of the government's information leads this court to the conclusion that the risk to the judicial process is nevertheless real, and that certain reasonable precautions should be taken to protect the integrity of the fact-finding process. The imposition to the defendants is modest indeed. Experience teaches that little, if anything, is sacrificed by withholding from counsel and the defendants the names and addresses of jurors. On the other hand, what will be safeguarded is the party's right to make informed choices about the qualifications of prospective trial jurors. Great pains will be taken to ensure each of the litigants the comfort of an informed choice. Accordingly, the court orders that the names, addresses, and workplaces of all jurors not be revealed. I mean, yes. You think? Here, I want to do another sidebar. If you were dealing with a different type of criminal organization, someone who was just trying to get, some people who was just trying to get some money lightly, but they didn't show a pattern of violence, that's different. Once you see that this organization and the members themselves have a pattern for not just beating somebody up, but also murder, rape. These things are different. These are different categories if this is always the go-to. You understand? And from reading this paperwork, it wasn't just like, it was our competition. It was, it didn't matter, in my opinion. This is me talking, me reading the paperwork. In my opinion, I don't think they really cared either way who it was going to be, whether it was going to be an officer of the law, whether it was going to be legal counsel, whether it was going to be a witness. So why would all these other people be candidates for consequences and not a jury? Of course the jury is going to, in my opinion, you could get it too. In my opinion. Let us finish this up. Accordingly, the court orders that the names, addresses, and workplaces of all jurors not be revealed. In addition, trial jurors will be transported to and from the courthouse by the United States Marshal or his designee, and jurors shall remain together during each workday under the supervision of the United States Marshal or other duly designated court security personnel. This order is subject to modification in the event the resolution of severance motions notions or other matters warrant reconsideration. So I think that is the end there. And I just want to say again, I understand this was over 30 years ago, right? Let's see, 90 to 2000 is a decade, 2000 to 2010, 2010 to 2020. And we are, so this is 35 years ago. This is 35 years ago. And I just want to say, this is a younger version of these people. So rehabilitation could totally have been an option. Right? I won't take that. Regret, rehabilitation. I will also say, though, time will tell. Some of these individuals are out, and we will see. You understand? I won't say too much, but I already started to see signs of their innate behavior starting to surface. And like I said before, you cannot solve every issue with a hammer. It cannot be, yo, show me where these people live. What are you going to do? This is 2026. Yeah, people got Ring cameras. People got all time. Is a camera? Never mind that people got Ring cameras. If you think for a second a camera's not on almost every corner clocking your movements, you understand? Are you using? I mean, I don't want to tell you how to commit crimes, but you know that cell phone is tracking you around, right? You got cell towers, man. You watch the first 48. So, everyone can't be intimidated to just be quiet because you don't want them to talk about your past. What happens is things will come to light and you have to deal with the decisions that you made years ago. I only discuss these things because it is public knowledge. You understand? And like I said, I'm a sociologist. I studied 4 years in my undergrad as a sociologist. So this is what I like. This is why my channel is called Society, Past, Present, and Future. Please hit the like button. Do subscribe to my channel and share. And we will continue on. I want to continue to recognize this type of behavior. In my next video, they're going to talk about legal counsel, who's like, yo, I can't do this. I'm getting threatened. And to me, this is just wild. These young people were absolutely out on the streets wilding. And the fact that some of them even got out of jail is wild to me. You understand? Because I'm going to keep it 1,000 with you. I would not want that type of person being my neighbor, right? So either I have to move, because I know me. I'm going to lay you down. This is a fact. And I don't want to have gone to jail because someone else didn't care about their life. And that's what it comes down to. You got to recognize when somebody don't care about their life. Their life means so little that they'll put anybody in the position to take their life. Because, nigga, listen. Why would I let you take mine first? It don't make sense. Got to lay you down, Jack. Anyway, thanks for subscribing to the channel. Hit the hype button, the like button. Hit all the buttons, man. See you in the next video. Peace out.